having served before the Supreme Court for almost 60 years, I have no interest in attacking the court as an institution. Rather, what I'm trying to suggest is that the court, in this decision at least, has brought criticism on itself. The court has always been subject to criticism, sometimes fair and sometimes unfair. It was criticized for the Dred Scott decision, for Plessy against Ferguson, for the Korematsu decision. All of those decisions, I think, have been repudiated by history, although they were rendered by majorities of the court. So the issue is not, is the court above attack on the merits of its decisions? The issue is, as I think you understand, is the decision that's under discussion today one that deserves acquiescence or not? And my submission is that it does not. I explained in my prepared statement that the decision is profoundly wrong and it is profoundly dangerous. It's profoundly wrong for several reasons. Notably, the court did not find any textual support for the decision. Indeed, the text points exactly the opposite. The court could not find an apt precedent in support of the decision. The only reliance the court could come up with, as Senator Graham mentioned, was a decision by a 5-4 court to grant civil immunity from private damage suits. Seems to me pretty obvious to any lawyers, even not constitutional lawyers, that the difference between immunizing a president from prospective liability to private citizens suing about official actions is fundamentally different from immunizing a president from culpability for committing crimes brought for violation of the same public interest statutes that apply to everyone else. The court could not rely on any historical practice in favor of criminal immunity. In fact, the practice is exactly the opposite. I know from my own experience in the Watergate affair that President Nixon was under active criminal investigation for his role in the cover-up. President Clinton was, President Reagan was. At no time before 2024 did any serious lawyer, nor did any of those presidents, claim that there was any kind of immunity from criminal exposure for crimes committed in office, including crimes committed allegedly in the performance of official function. The only issue that was debated during the Nixon period was whether the president could be indicted while still in office. Everyone, including President Nixon and President Ford, in granting a pardon, concluded that the president could be indicted for official acts after he left office. Constitutional text points in that same direction. The impeachment clause says that any person, including the president, whether or not impeached, is liable for indictment, prosecution, and punishment. And that necessarily includes official acts, because the only offenses for which a person, including the president, may be impeached are official acts: bribery, treason, and what are described as other high crimes and misdemeanors. Those were understood when the Constitution was adopted to be maladministration or the improper and possibly criminal performance of official acts. That indeed is what the term bribery means: taking money to perform an official function. Text of the Constitution could not be clearer that a president is subject to indictment, trial, and punishment for that kind of improper, that is, illegal performance of an official function.